Well, the two worst nights of Donald Trump's life so far are election night 2020 and tonight. On election night, when Fox called Arizona for Joe Biden, Donald Trump knew then that he was going to lose access to the White House and to Air Force One. And that's really all the presidency was to him. But tonight, Donald Trump is staring at the possibility of losing everything, including his freedom. Donald Trump began his day by getting hit with the most massive lawsuit he has ever faced, a lawsuit that could wipe him out and bankrupt his adult children. And Donald Trump ended his day about 2 hours ago by getting completely crushed, and I mean crushed, by a federal appeals court in a 29-page opinion and order siding completely with federal prosecutors against Donald Trump in the case of Donald J. Trump versus United States of America. Now, we have spent the last few weeks openly worrying that Donald Trump may have poisoned the federal judiciary to the point where laws do not apply to him. And that was the formally stated position of the Trump-appointed federal judge, Aileen Mercedes Cannon, who decided to appoint a special master to examine all the documents seized by the FBI from Donald Trump's Florida part-time residence, because she believes, and she put it in writing, that Donald Trump deserves special treatment in a situation like this, special treatment in American courtrooms. And that was a shocking decision by a federal judge and a shocking order by a federal judge. And you heard a lot of shock about it on this program, and we have insisted on this program with the unanimous agreement of our legal experts that the Trump judge's opinion was untethered to the law. It was a work of legal fiction. And tonight, a three-judge panel of the United States Court of Appeals for the 11th Circuit said, "We agree." They said those two words repeatedly in their 29 pages, and they literally meant, "We agree with the federal prosecutors." They literally meant, "We agree with every word the federal prosecutors have presented to us, and we disagree with every word Donald Trump's lawyers have presented to us, and we disagree with the federal judge who appointed a special master." But that "we agree" also extends, as viewers of this program will know, to mean, in effect, we agree with Andrew Weissman, we agree with Neil Katyal, we agree with Bradley Moss, we agree with Professor Lawrence Tribe. The appeals court agrees with every legal expert guest you have heard on this program for weeks now discussing this case. They agree completely. And here is the possibly most important piece of this agreement. Here is the inspiring part of this agreement that does not appear in the words of the 29-page opinion and order. Here is the reason for hope. Hope that Donald Trump's poisoning of the federal judiciary is not as extensive or successful as it could have been. Of the three judges who unanimously agreed with the prosecutors in this case and disagreed with Donald Trump, two of them were appointed by Donald Trump. Judge Robin Rosenbaum was appointed by President Obama. Judge Britt Grant was appointed by Donald Trump. Judge Andrew Brasher was appointed by Donald Trump. Their unanimous opinion contains the clearest history of this case yet written. And when describing the government records seized by the FBI at Donald Trump's residence, these judges did not say that those documents belonged to the government. They said that the documents, quote, properly belonged to the people of the United States. The people of the United States. That's who those judges were writing their opinion for. That's who they are representing in that opinion. And in that opinion, the judges said, the United States argues that the district court likely erred in exercising its jurisdiction to enjoin the United States' use of the classified records in its criminal investigation and to require the United States to submit the marked classified documents to a special master for review. We agree. The court said that the prosecutor's likelihood of success in pursuing this appeal is so high that they are now granting the prosecutors exactly what they are asking for: the right to continue using the classified documents in their criminal investigation and the right to refuse to give those classified documents to the special master for review. The appeals court said that the district court abused its discretion. Judge Cannon abused her discretion, and she did it to help Donald Trump based on nothing that exists in American law. The appeals court said the district court made no mention in its analysis as to why or how plaintiff Trump might have an individual interest in or need for the classified documents. For our part, we cannot discern why plaintiff Trump would have an individual interest in or need for any of the 100 documents with classification markings. The appeals court opinion included a history of the classification of documents beginning with World War I and introduced elementary concepts of classification in instructional passages to Judge Cannon, saying a person may have access to classified information only if, among other requirements, he has a need to know the information. This requirement pertains equally to former presidents. The appeals court knows what Judge Cannon pretended not to know, that former presidents have the same rights as everyone else who is not president and not working in the government. The judges said plaintiff Trump has not even attempted to show that he has a need to know the information contained in the classified documents. The three-judge panel was paying close attention to what happened in Special Master Raymond Deary's courtroom in Brooklyn yesterday. The judges wrote, plaintiff Trump suggests that he may have declassified these documents when he was president, but the record contains no evidence that any of these records were declassified. And before the special master, plaintiff Trump resisted providing any evidence that he had declassified any of these documents. And in a panic about classification tonight, Donald Trump actually appeared on Fox in a discussion with Sean Hannity, claiming that he did declassify all of those documents, and he claimed he could declassify documents just by thinking about it. Actually said that. But no Trump lawyers dare say anything like that in any of these legal proceedings. After pointing out everything that was wrong with Judge Cannon's approach to the classified documents, the appeals court then said that the classification does not even matter. In any event, at least for these purposes, the declassification argument is a red herring because declassifying an official document would not change its content or render it personal. So even if we assumed that plaintiff Trump did declassify some or all of the documents, that would not explain why he has a personal interest in them. He has not identified any reason that he is entitled to them. The appeals court said the district court abused its discretion in exercising jurisdiction over plaintiff Trump's motion as it concerns the classified documents. To Judge Cannon's legal reasoning on blocking the federal investigation of the classified documents and ordering them handed over to a special master, the appeals court said that analysis was in error. Instead of simply disbelieving the FBI affidavit that the FBI's criminal investigation is inextricably intertwined with the national security review of the abuse of those documents, the appeals court said, we believe the FBI affidavit. The appeals court relied solely, heavily, on an affidavit provided by Alan Kohler, Jr., the assistant director of the counterintelligence division of the FBI. Judge Cannon completely dismissed this affidavit, but the appeals court said Through Kohler's declaration, the United States has sufficiently explained how and why its national security review is inextricably intertwined with its criminal investigation. No party has offered anything beyond speculation to undermine the United States representation, supported by sworn testimony, that findings from the criminal investigation may be critical to its national security review. And so there's the appeals court, those three judges saying that Judge Cannon engaged in pure speculation, just pure guesswork, aided and abetted by Trump's lawyers, that the FBI's Assistant Director of Counterintelligence, Alan Kohler, was simply not telling the truth in his affidavit. The appeals court was shocked at that. The appeals court made a finding that essentially means that this case really is all over. There will be some more procedural twists and turns, but we know now how the procedure of this is going to end. The Justice Department is going to be allowed to do whatever it wants to do. And then will come the decision on whether to indict Donald Trump, a decision that will ultimately be made by Attorney General Merrick Garland. Here is the line at the end of the opinion that tells you that there's really nothing more to discuss procedurally. Plaintiff Trump does not have a possessory interest in the documents at issue, so he does not suffer a cognizable harm if the United States reviews documents he neither owns nor has a personal interest in. Thus, an injunction delaying or perhaps preventing the United States' criminal investigation from using classified materials risks imposing real and significant harm on the United States and the public. The United States also argues that allowing the special master and plaintiff's counsel to examine the classified records would separately impose irreparable harm. We agree.